A very good morning to all of you in the hall today. It's lovely to see such a full hall and all of you discussing IP on a working morning when we have only odd cars on the roads today in Delhi. I hope you've come to Delhi with lesser pollution and hope you all have a very nice trip to India. And it couldn't have been a better time to have the Global IP Convention. And India is sitting on, if I may say, a watershed moment or a period in IP. In the last 2 years, I mean, it's an unprecedented situation when the Prime Minister of India has spoken of intellectual property on at least 6 to 8 occasions in India and internationally. And I can see Dr. Ganguly nodding his head, so he agrees with me. So we are actually thinking of and hoping to create a very vibrant IP atmosphere in the country. And I think the time to organize the Global IP Convention couldn't have been better in Delhi. And it's good to see so many distinguished panelists to the left of me and a distinguished audience, a large number of friends, lawyers, both from India and abroad. A very warm welcome to all of you for this session. The topic allotted to this session is contentious issues on international conventions and trips. So we are going to have, hopefully, a very interesting session on the international scenario and the domestic scenario on where the world is going on IP. Are there requirements for any new conventions, multilateral trade pacts, or are we happy with the current situation in TRIPS? What are the dynamics of TPP, for example? Do we see more regional and multilateral agreements which are kind of developed world on the one hand, developing countries on the other, or are we going to see a global multilateral agreement like the TRIPS in the years to come? Before I hand over to the speakers or introduce them to you, I would like to place a few issues on the table, which I hope the speakers would address in their session, in their speeches today. Where is India standing on IP, and before that on an economic scale? In 2010, India had a GDP of 10% growth. However, everyone predicted that this is going to go down because we won't be able to sustain those levels. So, rightly or wrongly so, it did go down. We reached 4 to 5% in 2014. But now, there's an expectation that the growth in India would be between 7 to 8%, which I think is a conservative estimate. Now, what are the contentious issues on IP on the table for us? India has taken several steps in the last 2 years or so to beef up the administration of the IPOs. We've seen greater recruitment of examiners, new rules for expedited examination of patents. There's continuous training and collaboration with the WIPO and various IP offices. I see a representative from JETRO sitting here. So on the administration of the IPO, the biggest development in the last 5 to 7 years that we've seen is the online access to information, which was hitherto unknown. And I think that that has made a huge change in bringing more transparency and efficiency into the system. We also have a better court system now. The commercial courts and commercial division have been established as of the 1st of January 2016. And I would like to say that the lawyers, including Mr. Anand and myself, have worked very hard towards making sure that this legislation goes forward in the way it was structured, in the way it is friendlier to IP disputes. And the enactment is going to reduce time lags in IP disputes to a great extent. The expectation is that IP trials should conclude between 12 to 18 months. As per the timelines in the Act, it is 12 months. But even by going and saying that, okay, it could be a little more delay, the maximum period is 12 to 18 months, and the maximum period of 6 months to decide the appeal. So you could actually have suits being decided and appeals being decided from day one to the appellate stage within 24 months under the new Act, if we make it work efficiently. There are substantive issues that need to be addressed both at the Indian level and at the international level. We have substantive issues with respect to plant varieties, biodiversity, geographical indications, traditional knowledge on one side. We also have patents and the issues of software patents. Where does it go? Should India allow greater patenting in the field of software, in the field of computer-related inventions? Should we allow greater patenting in Section 3D and incremental innovation? These are the substantive issues that we need to discuss and develop right now. Do we need a better culture on damages? All these issues have to be debated today, and of course the time is not enough for that. We have a total period of 90 minutes within which we have to wrap up speeches of all the distinguished panelists and question answers. Do we need TRIPS Plus provisions like data exclusivity, patent linkage? Is it something to look forward to in the future, or is India not ready? Are we being left out in agreements like the TPP? Should India look at TPP more seriously? And of course, at the international stage, we have the Unitary Patent Court in Europe, and of course, the patentable subject matter issue in the US. So these are the issues I would like to place on the table for the distinguished panelists and for the session. And we have a very distinguished panel today, which includes Dr. Heinz Godar, and he is a very, very familiar face in India on IP. And he's, of course, from a very well-known law firm in Germany called Beumert & Beumert, and he also has an academic background. But I can only say one thing from my experience of Dr. Godar, and that is that he's a great friend of India. So I welcome Dr. Godar for this panel, and he would be speaking to us about the pros and cons of the forthcoming unitary patent system and the Unified Patent Court in Europe.